things to know about legal issues affecting the business of medicine. And in our practice, we try to be very cognizant of that, not lose sight of the fact that although healthcare is a highly regulated industry, at the end of the day, it's a business. And so we approach this as a business that is highly regulated. Of course, it's unique because of the nature of the practice. You're helping other people. You're dealing with high stress situations oftentimes. But there are certain business issues that come up, and I'm going to talk about some very common ones and then some trends that we're seeing. So the first thing is non-compete agreements. When I get asked, which is on a regular basis, to review or comment on physician employment agreements, or sometimes to draft them, or draft agreements for medical director relationships and so forth, this is one of the most hotly contested areas, also one of the most areas of the most questions, and frankly, I think an area with a lot of misconception. First things first is that non-compete agreements are enforceable in Florida. In fact, Florida is probably known now as one of these states where we have the strongest enforcement among the courts of non-compete agreements. But there are a lot of things that can go wrong. They have to be reasonable in time and geographic scope. Companies that try to overreach often see that backfire. And it must support a legitimate business interest. So the idea of just locking up all of your employees for no good reason other than to eliminate competition is not going to work. But what I really want to point out here is a recent statutory adoption that created an exception that pertains specifically to physicians and orthopedic doctors or osteopathic doctors, pardon me. I was just talking about my shoulder surgery recently. The exception is found in 542.336, and basically this applies to physicians who work in a specialty practice area where the employer is the only company or entity in a specific county in Florida that offers that practice. And when that is the case, then any type of non-compete will not be enforced because Florida has decided that it is against the public policy and should be against the law in Florida to enforce non-competes to essentially eliminate competition among specialty practices. So this started with some oncologists. I think we're the first ones to challenge the law or challenge a non-compete relying on this law. That was the first reported case in Florida, and it had to do with some oncologists that left a practice down in the Sarasota area where that was the only practice in the county, and they were successful in defeating the non-compete. And if your question is, well, this law just took effect, well, I don't have it listed up here, but it was a 2019 law, or is the statute only effective for agreements signed after 2019, or does it affect agreements signed before? And a lot of times we have to figure that out in law. And here the legislature made it very easy for us by putting language in the statute that says that agreements that would limit specialty practices to only one entity in a county violate the public policy because it limits healthcare availability to the residents. And so by putting that language in there, it tells us that if you have an agreement and it falls into that category, that non-compete provision is not going to be enforceable regardless of when it was signed. If it gets challenged now, it's not going to be enforceable. So that's one. Number two, this is another topic that comes up all of the time. I've dealt with a lot of business divorces, business breakups and partnerships where disputes arise, and probably the one industry more than anywhere where I've dealt with that over the last 15 plus years is in the healthcare industry. People get together, they go into business together, and then they have a falling out. And what we see, a couple big issues here. One, no governing documents. You need an operating agreement. You need something, a shareholders agreement, something that outlines the rights and duties of the parties, whether they be members or their shareholders or partners, however you want to be described, your rights to distributions, your voting and participation in management. You may have different classes of membership and so forth. And the other issue is dispute resolution. Think in the beginning of the relationship on how the relationship is going to look if it breaks up. And oftentimes we see 50-50 relationships where you have a deadlock and now the parties wind up in court. And if you wind up in court over an operating procedure or over your business, some type of business governance issue or entity or a partnership dispute, it's a disaster for everybody, for the business, for other people who are affected. So you can take a lot of steps in the front side when you start to get into business with somebody to avoid deadlock. You can have a manager or a member with tie-breaking authority. You can have escalation clauses where, for instance, a parent company resolves issues of a subsidiary, or where you have members that can break the vote a deadlock among managers. You can appoint third-party outsiders, have mediation provisions with cooling off provisions. And then finally, there's all types of creative ways that you can draft buy-sell provisions. One cautionary note on buy-sell provisions is make sure that I see a lot of these, and I see a lot of them that people just, I don't know if they pull them off the internet or it's some type of form document, and they're terrible. And nobody can follow them. Nobody can practically follow them. If your buy-sell requires somebody to just buy an interest and pay cash, a lot of people aren't in a position to do that. So make sure that it's practical, and make sure that it's something that the parties can perform. And that usually amounts to defining the specific timeframes during which you make an announcement, how the buy-sell procedures and the pricing is carried out, and then how it will be paid for. That's one of the most overlooked provisions that I see. So the third issue, another thing that comes up a lot, and again, not directly related to healthcare, but certainly affects healthcare professionals and all professionals for that matter, asset protection. Asset protection basics, things that you can do yourself, even without a lawyer. If you're married, having your personal assets titled as tenants by entireties it offers you protection, because take for instance, for me personally, as a lawyer, if something happens, luckily, I'm knock on wood, I have not been sued or had any professional complaints. But if I were to be sued for any reason, most common reason, by the way, has nothing to do with professional activities, it's car accidents. But if I was sued for some reason and somebody wanted to get to my assets, they would have a very difficult time getting to anything, because I don't own anything personally in my own name, with very little exception, retirement accounts and other types of assets that are not available to creditors. Everything is titled in the name of me and my wife. So with spouse, if you're married and you title things in the name of husband and wife as tenants by entireties, it creates a protection where you can't get to assets unless you have a claim against both spouses. That it creates an exemption against any claims against the individual spouse. There's a number of statutory exemptions that are set out for retirement accounts, educational accounts, obviously the homestead in Florida, annuities. And these are easy things to take advantage of. People can find them themselves. There's some articles online. I've written about it previously. But of course, if anybody has questions, I'm happy to address those as well. And then finally, insulating your business interests and your assets with some type of organizational structure. I can't believe how many folks I still see that operate, maybe have a dental office or a physician practice, and they operate in a building that they own or in a property that they own, and they own that in the same name instead of separating out that interest. And so that if the practice gets sued, the individual gets sued, that building, which is a significant asset, is also exposed. And it's easy to separate those out with some type of corporate insulation. And the key there is documentation, having separate entities, separate sets of documents, and then leases or license agreements, whatever would be appropriate for that particular situation. Even though you may be the one who's signing the lease on behalf of both parties, it's important to have that in place. All right, here's the fourth thing that really all physicians need to know about in this day and age, especially during the times we're going through, is telehealth. Telehealth is here to stay. We did have an administrative rule on it a couple years ago here in Florida, but now that has been supplanted by a statute. So Florida Statute Section 456.47. It's a 2019 statute that, 2019 statute that outlines telehealth and what it is and what the requirements are here in Florida. It provides for synchronous and asynchronous communication. Synchronous, the easy way to think of synchronous is real-time communication, and asynchronous is something that's not real-time, often referred to as store and forward. Think of taking photos that might be taken, or MRI photos, X-ray images that may be sent via some electronic means. And so it's not real-time communication, but there's still some question as to what asynchronous means exactly, but it's not real time. So the statute it does allow for pretty broad provision for services by telehealth, but it does say in a statute you can't use an audio only phone call or an email or fax. I've got some questions myself as to what audio only phone call means. For instance, is an audio only phone call just a phone call with somebody, or what if you take notes and you're relying on photos and you have something else? But that's probably a question that I could talk about for a half hour and cover it another day. Uh, on the licensing issue, if you're going to serve patients in Florida, you need to be a licensed physician in Florida. Or if you're out of state, if we have anybody out of state joining us today, there is an out of state registration procedure. It's not a licensing procedure, it's really a registration. It's just, it's outlined pretty clearly in the statute. You register as an out of state provider, provide financial wherewithal in the form of insurance or a bond, have a local registered agent, and a couple other steps. And so if you want to provide services here in Florida, they've made it pretty easy. Those have been relaxed, by the way, during COVID, so that other out-of-state providers can provide for patients in Florida. But the requirements are not very stringent in any event. And then finally, payment standards. Medicare has traditionally been very tough to get paid for telehealth, but they have relaxed standards significantly during COVID through Social Security Section 1135 waivers. We have seen loosened standards for how you can provide telehealth. We are actually seeing payment for modes of communication that were not available prior to COVID, such as FaceTime and WhatsApp video conferences with doctors, and folks are allowed to be in their home while they're getting receiving services, and the doctors can still get paid for that. That's really the key. Is one, how can you provide the services? Two, you want to make sure if you're the one providing the services that you have a mechanism to get paid. Private payer insurance companies, they're a little bit, you have to look at your contract, figure out what's available, sometimes a call to the payer or your representative there. One thing I want to point out is, although there's been a big push here in Florida for payment parity, that being the same payment for in-office services as services through telehealth, we do not have that by any type of legal mandate here in Florida. And I like this reference here. This came from a executive at CMS, I believe, called Telehealth, the Modern Day House Call. And here's our fifth point, and I just want to broadly talk about regulatory enforcement. Again, with all of these standards being relaxed during COVID, it's easy to look at that and think that that the industry is not going to be as heavily policed as it has been, but that is not the case. DOJ and OIG are very active. In fact, on September 30th, DOJ announced in about a half-hour press conference the largest ever healthcare fraud investigation and takedown in U.S. history, and a multi-billion-dollar what they call a scheme that covered 14 or so states, involved telehealth, it involved opioids, and several defendants, and that is ongoing right now. So that is very active. We're seeing a lot of our healthcare clients being audited through private insurance companies, getting audit letters and notices, even document requests to turn in audits and recoupment efforts. And we're also seeing situations where the private pay insurance companies are trying to either disallow or recoup claims for payments made that they are taking the position have been in violation of legal statutes, such as self-referral laws here in Florida, or some other statutory violation that makes the services unlawful, and they take the position if the services were performed or provided unlawfully, then they don't have to pay under the statute. There's a lot of litigation in that area right now. We are involved in some, so I can't really comment on it that directly, but some of it involves, again, opioids is a hot topic, the PIP statute is a hot topic, and telehealth right now is a hot topic. And ironically, I wish I had a little bit more time, maybe if we have time at the end, I just received a telemarketing call from somebody. It was clearly just a pure telemarketing spam call from somebody trying to get me qualified to receive some more orthotic braces for my arthritis and have Medicare pay for it. So obviously, fraud alerts galore there. Know with these lawsuits that physicians are being named as defendants and physicians are targets. And I would just close here by saying that if you're going to get into business, any type of business arrangement, if you're going to be a medical director or a physician for a group, know who you're getting in business with, especially if it's one of these telehealth companies or it looks like it's a new technology. We are seeing a lot of issues where I think the physicians are totally innocent, but they may be they may not know that these scammers, like the person who just called me, are actually calling with these scams, and the physicians end up being a victim because they end up getting caught in the middle. And again, we are representing some physicians right now in some of that litigation, and we've been watching it very closely. And I appreciate again you giving me the time to present that. My contact information is available for any further questions. Thanks.